Thank you. Good morning. Please be seated. We are here in our cause number CACV120539 in the matter of Michael A. and Betty A. Johnson versus State Farm Fire and Casualty Company et al. It's time set for oral argument. Each side will have 20 minutes to argue, and we have both claims and cross claims here, so we'll let you manage the clock in terms of, because we have a claim, you've got a response, if you want a rebuttal, cross-claim, or you can jumble them up, but you have 20 minutes to do it. We are recording this, so if we need to listen to it later, so as you come forward, just please identify yourself and your client. This may be also videotaped. Well, I think they can hear me.
I'd turn mine off.
It's on. It's green. It's a go. I learned long ago, green means go. We're videotaping, which the court has just begun to do, and it may end up on YouTube, so, tell your friends and your family. But we have read the briefs. We have conferenced this matter. We believe we have an understanding of the issues that are being raised, and with that in mind, Mr. Silverman.
Good morning. May it please the court. My name is Stephen Silverman with Treon and Shook on behalf of the Johnsons, who are also present. And time permitting, I'd like to reserve 10 minutes for rebuttal. With respect to what the primary issue in this case is what's the impact, what's the effect of a judgment entered pursuant to Rule 68? We respectfully submit that State Farm has the understanding of Rule 68 and the consequences of a judgment entered pursuant to Rule 68 completely backwards. With respect to the issues related to res judicata, or probably better to use terms claim preclusion and issue preclusion, the North Point decision, which from our perspective provides almost all of the answers to the issues that are currently before the court, provides that there is claim preclusion, but there is not issue preclusion that follows from a judgment entered pursuant to Rule 68. Now what that means is, with respect to the factual assertions made by State Farm that they acted reasonably in the underlying claim, that those considerations are barred as a result of claim preclusion. The issues that were necessary to support the judgment, and that's the end of claim preclusion, that is the preclusive effect that pertains to the factual allegations. In other words, it's established that State Farm breached the contract, that State Farm acted in bad faith. And with respect to the events that occurred up to May of 2006.
What is established in your judgment as a result of the Rule 68 process and judgment in regard to the counterclaim?
With respect to the counterclaim, if from a factual perspective, State Farm lost. The judgment was for the Johnsons. So
weren't you seeking more than that amount? Is it possible that you would have prevailed? You would have, say, received $500,000 and that they were entitled to $250,000 on their counterclaim? Isn't it just an overall judgment in your favor, in your client's favor, as opposed to a specific judgment on the counterclaim?
no, I think the judgment, and I can get the precise language in the judgment in front of me, but the judgment specifically provides that the recovery was for the Johnsons on their cause of action and against State Farm on its cause of action. So the judgment itself speaks clearly on the subject of what was entered.
So you believe that means that in some way at least, that the Johnsons won the counterclaim as well as the underlying claim?
Yes, I mean, as it relates to, because the flip side of the issue from the claim preclusion effects as it relates to the facts, and the facts, at least on appeal, are the facts that are set forth in the amended complaint. Jury may deal with fact disputes at a later point in time, but at least for the purposes of the standard of review, it's the amended complaint facts. But the effect of the Rule 68 judgment on what facts are potentially in dispute in a future proceeding, in the event that the court agrees with me, that's an issue I think that Judge Ray would be able to work out. The issue, though, is with respect to the judgment, and I think this answers your question, and if it doesn't, I'll try again, is that from a respective favorable determination, the judgment is conclusive. It's despite the fact that it's issued pursuant to Rule 68, it's still a judgment. And in the absence of a judgment, if we had just taken, hypothetically, and this didn't happen, and I can explain the circumstances of why the settlement didn't occur. It's loosely part of the record.
Not part of the record on appeal.
It wasn't briefed, but the issue of if we had received $250,000 by way of settlement, and the settlement agreement didn't provide for a release of any and all claims, which just in my experience as doing primarily insurance litigation on behalf of policyholders would be very unusual. But had this case settled, and had it settled in the manner in which almost every case that I've litigated that has settled has been resolved. If it didn't have the link, if there wasn't a release of other claims, under the Bradshaw versus State Farm case, there would be a fact question as to whether or not there was a favorable determination. A judgment, in other words, isn't a necessity. And the Bradshaw versus State Farm case makes that clear. And that's emphasized again in the Chapman versus Schneider case. Those are from our perspective, the two leading appellate decisions that relate to the elements and the requirements for a malicious prosecution claim.
Well, if the North Point case applies, the principle from North Point, if it applies here, it applies in your favor, and you have a favorable termination.
As a matter of law, yes. So my point being, at least with respect to, and I appreciate that Judge Ray went out of his way to make a clear record on this, because I think from his perspective, the issue wasn't settled by North Point. But we believe that it is, and but even if
wasn't the issue in North Point whether you're entitled to attorney's fees? You clearly have a judgment, so you would be entitled to attorney's fees, but that still doesn't seem to me to answer the question of what was the ruling, what was the judgment on the counterclaim?
Well, I would respectfully submit that the North Point decision provides that a resolution by way of offer of judgment, by way of Rule 68 proceedings, is a determination the same as if a jury reached a conclusion. It reached, in other words, North Point specifically states that a Rule 68 judgment is the same as if a jury had entered the verdict. So from...
And I agree, and without a counterclaim, it seems like a real clean issue. But if you're saying I'll have to look again at the court's order, but there's a specific order. The order addresses the counterclaim, and my recollection is it doesn't say the counterclaim is entirely frivolous or without merit. It's just there's an overall judgment, and it resolves the claim and the counterclaim. But am I wrong on that?
Well, I guess the judgment was for the Johnsons. In other words, they received a favorable result on the termination of the lawsuit. When I come up for my rebuttal time, in the meantime, I'll pull the language of the judgment out and speak more specifically to that. But whether or not in other words, if there wasn't a judgment, or if the judgment isn't conclusive under Bradshaw, it would then be a question of fact. But our position is, with respect to the proceedings here and the record that we have here, the fact that we got a judgment on the underlying action, instead of it being a fact question, is an issue that we win as a matter of law.
Excuse me for interrupting, but could you change issues slightly and address State Farm's argument that res judicata ought to apply here, and there's nothing left to litigate?
Well, first of all, when they talk about the different forms of preclusion, I think they're mixing up issue and claim preclusion. So there's no issue preclusion.
My mind still goes to the old names, but I'll try
Yeah,
to keep them
well,
straight.
in the old names, at least in my understanding is that res judicata was issue preclusion, and North Point says that that's not in play with respect to a Rule 68 judgment. The other critical point with respect to the malicious prosecution claim is that the claim didn't accrue until the judgment was entered. So there's no way for an inchoate claim to somehow be precluded.
I think State Farm's argument, if I understand their brief correctly, is that they sort of admit that it wasn't fully ripe yet until the prior litigation was terminated, but that it's all the same issues that were framed in the case that has been resolved with a judgment.
Well, that would run afoul of the Supreme Court's direction from the North Point decision that claim preclusion and not issue preclusion be the results of a Rule 68 judgment.
But what damages would you have been seeking had you gone to trial on the counterclaim?
Well, the Chapman decision, and it's we addressed this specifically at well, actually, I'm not sure. We have a point that's related to that we address in our opening brief, and I think we address it specifically in our reply brief, and I'll bring that up again on my rebuttal time. But specifically, same as in the Chapman versus Schneider case, if State Farm had only defended the case, we wouldn't be here. But they initiated litigation against the Johnsons, and they in their briefing they essentially
Isn't that what you raised in your counterclaim?
well, they raised the counterclaim. We filed the underlying case.
Well, but you responded in terms of an affirmative defense with respect to malicious prosecution in response to their counterclaim.
Well, the issue of if there were any specific issues from the underlying case that may have the potential for issue preclusion, there was no resolution of those issues. So the only issues that were necessary for supporting the original judgment, the 2010 judgment, are the facts necessary to support the bad faith and the breach of contract causes of action. The malicious prosecution action, there's a difference between making a statement in the course of proceedings that the other side is acting maliciously versus being able to have the facts to establish the cause of action. And Judge Ray addressed that specifically by saying if the judgment is what is accruing the cause of action, there's no way the judgment could have extinguished it. So that's how I see that specific issue. And what they say in response to that in their briefing, what they say is that under Bradshaw, because they didn't file the lawsuit, they only counterclaimed, Bradshaw's not applicable. But we cite the authorities, and there's no contrary authorities, that say that if you counterclaim, you have immunity from a malicious prosecution action. And in fact, the Chaplin versus Schneider case in substantial respects arose out of a counterclaim, a maliciously prosecuted counterclaim. And unless there's any further questions at this time, I'll pull those two pieces of information and address those first when I come back up.
Thank you.
Good morning, Robert Sullivan from Broning, Oberg, Woods and Wilson on behalf of State Farm et al. Plaintiff's counsel or appellant's counsel stipulated to the fact that claim preclusion would have been triggered under these facts. And when you think about this case in terms of Arizona law and really law of the entire country, there are two broad legal principles that come to mind, and those are res judicata and no double recovery. And the court is faced with a situation where there's a technical issue on whether or not the judgment from the underlying case resolved all claims and counterclaims for purposes of applying res judicata or the theory of double recovery. And I think those two marry well in terms of the theories behind them and the application of them.
Can I interrupt you for just a second?
Sure.
Just factually, did any of the conduct that's been alleged occur after the settlement or after the judgment was entered?
Nothing in the record, Your Honor, and nothing that I'm aware of.
And the disclosure of information that occurred prior to the judgment?
Yes, Your Honor. What's
Yeah,
important?
that surprises me. Somewhere I got the impression that there was some disclosure of information by State Farm regarding the Johnsons after the judgment.
If you're referring to the Avery disclosure of information, you can find that information in the record 38 Exhibit C at 1 and 4, and Exhibit B at 3, Note 1.
Got it.
And what that portion of the record specifically says is that was raised during the underlying bad faith claim. And that's really the point and the theory behind claim preclusion. Have they asserted a claim for the same or identical damages? And when you look at whether or not the bad faith claim that was brought in the underlying case and is now barred by res judicata or claim preclusion, you have to make a determination as to whether or not a malicious prosecution or wrongful institution of a legal proceeding claim constitutes the same type of theory or allegation such that it should be precluded. And the answer to it is yes, and this is the reason why. The elements necessary to bring the malicious prosecution claim are 5. Whether or not a civil proceeding was instituted. Yes, and also what? The basis of the bad faith claim, right? There was a motion in limine brought by State Farm asking the court to preclude the rationale behind the filing of the counterclaim. That was denied. There was a motion to compel filed by the plaintiff's counsel asking the court to seek discovery into the reasons that the bad faith claim was filed. And in that very documentation, the plaintiffs state over and over again, 1, under Arizona law, Tucson Airport Authority case, you have a continuing duty of good faith and fair dealing during litigation.
Which is true, right?
Absolutely true. And as such, the filing of the counterclaim can and should be looked at in terms of whether or not it is part of the plaintiff's claim for bad faith and the corresponding damages associated with it. Judge Ray agreed with plaintiff's counsel in the underlying proceedings. They had their bite at that apple with respect to it, and as such, it's barred by the doctrine of res judicata or claim preclusion, if you will.
Is there, I think I'm following what you're arguing, but isn't it still true that a claim for damages for malicious prosecution hadn't accrued yet and is different from the defensive allegation in the answer to the counterclaim of malicious prosecution?
I'll agree with the first part of the statement. I disagree with the latter part of it, and here's why. Yes, under Arizona law, unequivocally true, you cannot file the malicious prosecution claim until there has been a termination in the plaintiff's favor in the underlying litigation.
If you undertake to file it as a counterclaim, in fact, it would be dismissible.
I'm sorry.
If you undertake to file a malicious prosecution claim as an affirmative counterclaim, seeking damages before the for the other case, it's not over yet, it would be dismissible.
It would be dismissible. But the second part of your question is really the fundamental issue here, and that is whether or not the claim for damages from the filing of the lawsuit has already been brought. And we know the answer to it. We know that the answer is yes.
Well,
That
something very similar, certainly.
identical. It's what they claim is bad faith in the underlying case was the filing of the lawsuit. And if it's identical and they're making a claim for the damages as a result of the filing of the lawsuit in the underlying litigation, then those damages have been resolved. And you can't have a malicious prosecution claim absent the damages associated with what? The filing of the lawsuit, the
May I
institution of
see
legal
if-
proceeding.
May I see if I'm following you correctly, and correct me if I'm not.
Sure.
You're not simply arguing that the answer to the counterclaim that asserted as a defense or in defense malicious prosecution and/or abusive process. You're not simply arguing that that put these issues before the court. You're actually also arguing that because they asserted and got the judge to agree with them that the filing of the counterclaim itself could be an act of bad faith, that was actually before the court, even just as between the complaint and the answer.
That is
And the counterclaim.
That is precisely the argument. And we know it, and we know it how. We know it from the exact evidence and position that the plaintiffs took in the case. They took the position in briefing in the underlying litigation that the evidence regarding the filing of the counterclaim and the rationale behind it is, this is a quote from their brief, the evidence is relevant to the bad faith claim. And they go on. They say the fact that the counterclaim was retaliatory is, quote, relevant to the bad faith case. They go on. State Farm's counterclaim can be inferred to constitute an act of bad faith, and the plaintiff should be permitted to introduce evidence and arguments regarding the bad faith filing of the counterclaim.
And
They
that-
made
that-
the choice.
And that was going to happen.
Yeah, they made the choice at that time that they were pursuing the damages associated with the filing of the counterclaim in their claim for bad faith. And as such, it is, as a claim, precluded from being brought again. The only,
Sorry, Dan. Well, I was just going to say, does your argument here that you're making depend in any way on a determination of whether the counterclaim was resolved favorably to the Johnsons or unfavorably or unknown?
two different questions. One is it barred by claim preclusion or res judicata? That is, has it been brought?
And I think you're arguing, if I'm following correctly, you're arguing that stands alone.
It stands alone. Secondly, are they precluded from bringing a malicious prosecution claim because there's been no determination in the plaintiff's favor in the underlying litigation? Either one of those results in an opinion that should be favorable to State Farm. And here's why, with respect to whether or not it's been a resolution in favor of the plaintiffs for purposes of bringing a malicious prosecution claim, that it hasn't been. Plaintiffs' counsel is correct. North Point controls this issue. Your Honor is correct that North Point didn't deal with this issue. Unequivocally, what North Point dealt with was whether or not there's been an adjudication in favor of one of the parties in terms of awarding attorney's fees. Why is that important?
As opposed to a settlement.
Exactly. Well, one reason it's important is because they're trying to effectuate the purpose of Rule 68. Rule 68 contemplates the possibility of attorney's fees. In order to bring the matter to a conclusion, they have to make a determination as to whether or not there's a successful party, an adjudication on the merits, for purposes of finalizing Rule 68. What that doesn't run afoul of when they make that determination is the purpose of Rule 68. Purpose of Rule 68 is to what? To bring the matter to a final, ultimate conclusion, to facilitate settlements, to unburden the courts with cases that are brought to a resolution. That's why the court ruled that way. And if you read the language of it carefully, they specifically say, we are just construing this. They say, we're going to do a statutory interpretation. Well, we're not talking about a statutory interpretation with respect to malicious prosecution claims. They were talking about with respect to attorney's fees. To boot, that section of the statute that was interpreted by the court is no longer in the statute, so they're interpreting a statute that no longer exists. But that's, I think, a bright line distinction. And what else do we know from the North Point case? And they're very clear on this. The entry of the judgment with respect to an offer of judgment is perfunctory by the court. And why? Because you're making a determination of what? Whether or not there's been a settlement. That's it. So then you have to go to what? The terms of the settlement itself. And the settlement itself is the offer of judgment. It's the offer, the acceptance, and the judgment. And the offer of judgment in this case is very, very clear. And it is an offer in the sum of $250,000 inclusive of all damages, taxable court costs, interest, and attorney's fees. So to the extent the plaintiffs took the position in the underlying litigation that they were damaged as a result of the filing of the counterclaim, which is the basis for the malicious prosecution claim as well, that it was settled when the offer of judgment was accepted. And to stand back, know that that's the offer of judgment, accept it, have the judgment entered, and then come around the back and say, we got a malicious prosecution claim too. Even though we've already settled, literally settled, that's the purpose of Rule 68, our claim for damages as a result of the filing of the counterclaim.
Could State Farm, as the offeror, have put in a sentence that said, and the parties will agree that no further litigation will ever be brought between the two of them?
Was it possible for State Farm to do that? Absolutely. Is it necessary under Arizona law? No. Why? Because that's the very fundamental purpose of Rule 68. You want the matter concluded. And when, I think they did, not explicitly the way you're saying, Your Honor, but when you say this $250,000 is inclusive of all damages, and the plaintiffs have taken the position in the underlying litigation that, hey, we're entitled to bring the counterclaim to the jury, and if State Farm files a motion in limine on the issue saying, hey, we think that's discreet, and plaintiff's counsel comes back and says, no, it's not. You have a continuing duty of good faith and fair dealing, and the judge says, hey, the counterclaim is going to the jury. And the jury would have been entitled to award damages as a result of it if they found that it constituted bad faith. So in the body of the facts of this case, it's very clear that the offer of judgment resolved all damages, including the damages for the filing of the counterclaim. And that is claim preclusion. That is res judicata. That is preventing double recovery, which we all know no courts say you're entitled to double recovery. All that's happening is the same action, and these are the things for malicious prosecution: instituting a civil proceeding, motivated by malice, begun without probable cause, damages, and the one that wasn't brought up yet was terminated in plaintiff's favor. Well, four of those items are not similar to what was brought with respect to the bad faith claim. They're identical to what was brought with respect to the bad faith claim. Discovery into the state of mind of State Farm, discovery into the rationale behind the filing of the counterclaim, cited to you by the plaintiffs in the briefing, in the record in this case. The only issue is one of a timing issue on whether or not it was ripe. And no one says just because a claim isn't ripe, res judicata can't apply. The issue is whether or not it has been resolved. And so we know from the facts that it has been resolved. And that's why the res judicata claim applies to bad faith, which seems abundantly clear and no one even seems to be focused on anymore, and malicious prosecution, and any other claim for the damages that would have been related to that case. The practical effect of it is this: if not, anything that goes on after a certain period of time, they could just file another lawsuit for. The purpose of res judicata and claim preclusion is to make sure everything's brought together and resolved, and that runs wholly consistent with what two theories? No double recovery, and our Rule 68 means the case is over in the state of Arizona. Those are all consistent. And if we bust it up, which is what the appellants are asking you to do, I think we're running afoul not only of the exact language of the courts themselves, but we're running afoul of the broad legal principles and those broad legal ideas that ought to be adhered to.
When the judgment was entered, pursuant to Rule 68, when it was entered, was there any remaining contractual relationship between State Farm and the Johnsons?
I don't know whether or not they were still insured under the policy at that time, but whether or not they were still insured, that's not the issue, because the duties and obligations of State Farm to act in good faith and fair dealing was to treat that whole claim with good faith. And so, to answer your question, I don't know if there's an actual contract in place, but I think the duty still existed, and certainly they were claiming an ongoing duty, and they knew they were making that claim of an ongoing duty throughout the litigation, and the offer for damages was done.
Would that ongoing duty, in your view, terminate with the judgment?
Yes. And the reason is,
Unless there was, well, unless there was a continuing contractual obligation, then there would be the regular implied covenant of good faith and fair dealing.
sure, it terminated with respect to the handling of this claim,
Right.
the handling of this insurance claim for the fire loss. If there was still an insurance policy in place and they had another loss, of course, there would be an ongoing duty, their
How about the
insurance.
three individuals they've sued?
Well,
They weren't parties to the judgment.
they weren't parties to the judgment, but we know under Arizona law, and we cited the case in our brief, that agents of the parties that are protected by res judicata are afforded the same protections. We also know that with respect to the claims against these individuals for, one, malicious prosecution, and two, for bad faith, they can't stand under Arizona law against individuals for a number of reasons. One, none of those people instituted a legal proceeding at all. They weren't parties to it, and that's kind of the reason they're not parties to the judgment.
Do they really have to actually institute a legal proceeding, or is it sufficient if they advise the corporate fictional entity to I mean, it's a real entity, but
Sure.
we fictionally treat corporations more or less as persons.
Sure.
What if they advise, or what if they make the decision?
And I think that's a fair point, and I think that's answered in our briefing pretty clearly, that when you're acting in the course and scope of your employment, the actions are for the employer, and you're not individually liable for those. And then what kind of is helpful, and I was surprised that we found it, there's a California case directly on point, says you can't conspire is what you're really talking about, getting together and saying we're going to do this. You can't conspire with your employer. Why? Because there's no individual liability for your action. And so they're not going to let you be liable for something under the theory of conspiracy when you can't be directly liable for the action. But those two cases are both cited in there. The one that's directly on point is the California case, but interestingly, it's based on the Arizona theory of why you can't do that in terms of liability. So those are the reasons that those, I should also say, all of the theories with respect to State Farm, the res judicata theory, and I think it's a valid point under the North Point holding and the rational Rule 68 that there has been no termination in the plaintiff's favor. And to be honest with the court, I was surprised that I came to that resolution after reading and rereading North Point, because when I first read it, I read it as, this case isn't very good for us at all. And when I reread it and then read it again, and I said, this case is exactly on point for us all and supports our position both on the res judicata element and on the termination in the favor of one of the parties. So those two defenses.
Tell me why you reached that conclusion in regard to the favorable termination issue.
I reached that conclusion because the analysis done by North Point is exclusively focused on the language of Rule 68 as it applies to the attorney fee award.
Right.
And then
Under the language of the statute, was it an adjudication on the merits or whatever the language is?
Precisely. And then I read that in conjunction with the rationale behind Rule 68, which is to effectuate settlement. So then I thought they needed to make this determination so that Rule 68 could completely resolve the case once it was over, once the judgment was entered, and it would be done on all issues, including attorney's fees. And so it would bring the matter to a final conclusion. So when I read it and reread it, and then when I read the language in the North Point decision that identified the fact that this is a settlement and that the entry of the judgment is more perfunctory in nature, then I was like, okay, so outside of the scope of Rule 68, it's not an adjudication on the merits in the favor of a party. Inside the rule of Scope 68 and interpreting the attorney fee statute, it is, so that you can bring the matter to a final conclusion.
So you would still say, in a large and real sense, that the judgment of the Johnsons against State Farm here was a settlement.
Absolutely, Your Honor. Absolutely. Because that's why we have Rule 68, and that's the purpose of us trying to implement it in its entirety. Thank you.
Thank you.
Sorry.
Mr. Silverman, before you begin, could I ask one factual question?
Sure.
You probably saw that I was a little confused about this point. Are the Johnsons alleging that after the judgment, State Farm did something bad to them?
Well, it's the answer to that question is it's not framed in the pleadings. And the reason for it, and it kind of goes to the core of my rebuttal. And I had promised to answer those two specific questions, but I'll get to that in a moment. To those two specific questions in a moment.
It's okay with me then for you to follow your plan rather than my.
No, I'll address the question now because it's central. What I heard over the last 20 minutes was a misunderstanding of claim preclusion and issue preclusion, a misunderstanding of res judicata because of the way that State Farm is interpreting the word claim. In this particular case, as it follows from the preclusive effects of the judgment in this case, the claims are the bad faith and breach of contract claims that are in the May 2006 complaint. The judgment that would be entered into the case as the case was pled, the underlying case, could only address damages up to May of 2006. There were no other claims, as that word is understood, for the purpose of preclusion, of analyzing the impact of the Rule 68 judgment. The issues, what counsel was discussing were things that would be pertinent if there was an issue preclusion issue, but there wasn't.
So if the case had gone to trial, the only damages that the Johnsons would have been seeking in that trial were damages up to and prior to May of 2006.
May of 2006, yes.
Complaint was filed.
Yes.
But you wanted to bring in the counterclaim.
And
You were bringing that in as evidence of bad faith then and not of additional damage.
well, it's part of defending it. If somebody accuses you of fraud, you're going to respond to that accusation by saying not only is it not fraud, and it's what the records in the underlying case showed, was that they knew they couldn't be suing the Johnsons for what they were suing them for. That the adjusters were talking about, we've got additional items that we have to pay. They paid the Johnsons $40,000 6 weeks before they filed the counterclaim. Or I might have the exact days wrong, but the general time reference is correct. And nothing had changed with respect to their information or belief about the case. So they acted in connection with filing that counterclaim, a jury could conclude, and it's the facts for the record here, with the intent of not effectualing a resolution of the issues, but to try to terrorize the Johnsons. And as part of a campaign of terror that continued after May of 2006.
You would have wanted to and hoped to bring in the counterclaim as part of bad conduct, right?
Well,
but not as a damage element. Is that what you're saying?
Well, we wanted to bring it up, and this is a critical point, and we address it. And because I got my pages a little bit out of whack, I don't think my notes are. We do specifically point out in the briefing that we were precluded from bringing in all of the evidence related to the conduct of Bogue and Hunsaker and State Farm in connection with their decisions to initiate the counterclaim. And it's an important point, and I'll.
What precluded you from doing that? Because at least State Farm, when they filed their motion to dismiss, attached all of the underlying documents, which really then, and although you sought to have the trial court strike it, it didn't. So in essence, a motion for summary judgment.
Well, we actually have it. It's in our appendix at tab 2 at pages 24 and 36, there's an acknowledgement by Judge Ray in contravening the exact point that State Farm said below to Judge Ray in the proceedings that this follow from, that no, I didn't let the plaintiffs get into everything. So factually, it's an incorrect statement. And again, it's part of the transcript, it's part of the record. It's at pages 24 and 36 to tab 2 to our appendix. So factually, that's incorrect.
Oral argument.
Yes.
Okay.
And so it was a statement that when was made to Judge Ray knew that statement wasn't correct because he knew what he ruled. And so that's a, but to get back to the point where I started on claim preclusion, issue preclusion, if something is raised in a proceeding, if there was actually an adjudication, a specific adjudication that speaks to the issue of State Farm, their conduct, their motives, that is in essence like a summary judgment type ruling, that would have issue preclusion effect. But claim preclusion is different. Claim preclusion and the claims are bad faith and breach of contract up to May of 2006. As it relates to anything else, and we talk about I'm going to try to.
Can I interrupt? Sorry.
Yeah.
If this had been a settlement, an overall settlement, would you agree that there's, as opposed to a Rule 68 judgment, this is just a settlement agreement between the parties? Would you agree that that ends everything and that you couldn't bring a subsequent malicious prosecution?
If they had taken us up on our attempts to settle, then, and the settlement agreement spoke to any future or possible claims, then there's a chance it could have. It just would depend on the specific contractual language between the Johnsons and State Farm. But paragraph 28 of the North Point decision rebuts the entire premise of State Farm's argument that they just gave and speaks to the issue, which is that if you just go through and you read paragraph 28 and you separate the words attorney's fees for malicious prosecution and county or Maricopa County for State Farm, it's not a settlement. Rule 68 isn't a settlement. It's a coercive instrument that puts into play very severe consequences if it's not accepted. And I pulled the judgment, and their offer, at the end of their offer, they say, by the way, plaintiffs, if you don't take this and you go to trial and you don't do better, you get double expert costs. Well, this wouldn't be an issue had they not counterclaimed. And that's the point that they're missing. In an ordinary insurance dispute, insurance companies don't engage in the kind of conduct that State Farm engaged in here. But State Farm engages in this conduct because one of our leading cases is same lawyer, same insurance company, same motive, same actions. And that's, we are here not because of anything the Johnsons did, we're here because of what State Farm did. So the judgment itself, and then I'm not a lot of time left, it says.
So they're not a good neighbor.
Not to the Johnsons, they weren't. They got in with their bad neighbors. The judgment is entered in favor of Michael and Betty Johnson against State Farm Fire and Casualty. So it's a judgment for the Johnsons against State Farm. So I'm out of time. I'll answer any other additional questions, but.
Well, did you finish the two main points that you had intended?
Page 9 of our.
If you could do a second, close that off in 20 seconds, I'd appreciate it.
I could probably do it in 5 seconds. If you look at page 9 of our reply brief, we talk about the specific damages that we're talking about that followed after May of 2006. It's one thing to have your insurance claim denied in bad faith. It's quite another to have the prosecution of your rights, have your liberty, your financial solvency put into question. So that's what the case on remand would be about.
Thank you very much.
Thank you, Your Honor.
Appreciate the argument of counsel. It's been helpful. We will take the matter under advisement and issue our written ruling in due course. Until then, we will stand adjourned and get ready for our next matter. Thank you.
Approached before.
What's that?
I haven't approached